Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on your income, so that means the less you make, the less you pay. Today, I want to take a moment to talk to you about spousal privileges. What is a spousal privilege? Well, it's a rule of evidence, and basically what it says is that one spouse cannot be forced to testify against another spouse, with certain exceptions. So, what does that mean? So that first of all, we have to look at the relationship between the parties. So the parties must be legally married. This does not apply to any common law marriage or marriage that's not recognized by the Commonwealth of Massachusetts. So you must be legally married in order for this privilege to apply. And a privilege is simply a rule of evidence that prevents the Commonwealth, in this case, from forcing you to testify against your spouse. So you have to be legally married, as I say, and it prevents testimony from one spouse against the other spouse about something that happened. And it applies. You have the time frame that you have to look to is are the people married at the time that the privilege? I'm sorry, at the time that the testimony is going to be taken. So it doesn't matter if the couple is married at the time of an event. It only matters if they are married at the time where the Commonwealth wants one spouse to testify against the other. So most commonly, we see the spousal privilege apply to domestic violence cases. In Massachusetts, that crime is called assault and battery against a family or household member, but it's domestic violence. A lot of times, what happens is couples will get into an argument. There will be perhaps some touching one to another. The police get called. They come out. They suspect that it's a domestic violence call. So somebody's going to get arrested. Pretty much all the time, someone is going to get arrested. Perhaps both parties could get arrested, but someone would be placed under arrest if there's any indication at all that there's been domestic violence. Oftentimes what happens is the complaining witness, that is the person who probably called the police, but not necessarily, but the person who's the alleged victim, doesn't want to testify against their spouse. Very commonly, it happens that the wife is not willing to testify against her husband, who is the defendant. Of course, that doesn't always have to be the case. It could be the other way around. And in Massachusetts, with same-sex marriages, it could be wife and wife or husband and husband. But in any case, the alleged victim is the one who has been harmed, has been offensively touched. That's what an assault and battery is. So later on, they perhaps patch things up. They want to get back to the way things were or whatever. That person does not want to testify, does not want to jam up their spouse. So the Commonwealth wants to call them as a witness. That person has the legal right to refuse to testify against their spouse. And a lot of times what happens is that's the only evidence that the Commonwealth would have to present against the defendant. So if there are no third-party witnesses, if there is no video surveillance, say, or any other evidence that the Commonwealth can proceed, in most cases, the case would have to be dismissed for lack of prosecution, for want of prosecution is what it's called. That just means that without the testimony of that witness, the Commonwealth can't go forward with a case, and we would move to have that case dismissed. So another thing to keep in mind is that it's the witness that holds the privilege. That means it's not up to the defendant. So the defendant can't say, I don't want my wife to testify against me. That's not how it works. It has to be the witness, the alleged victim, that claims the privilege. It's that person's privilege alone. They can exercise it or not. Simply because they're married doesn't mean that they won't testify against the defendant. They still have the right to waive that privilege and testify anyway. And sometimes that happens. But they have the ability, if they wish, to not testify, to refuse to testify, and probably the case would be dismissed. There are exceptions to this, however. The spousal privilege does not apply in civil cases. So this is only in a criminal context. So if it's the Commonwealth versus the defendant, that's a criminal case for the charge of domestic assault and battery. It does not apply to grand jury testimony. So if you're called to go before a grand jury, you cannot invoke this marital privilege and refuse to testify. You still have to testify in front of the grand jury. If that later goes to trial, if the grand jury returns an indictment and it proceeds in superior court, that then at the time of trial on that case, then you can refuse to testify if you so desire, if you're married at the time and you don't want to go forward. It also doesn't apply to cases of non-support, desertion, neglect of parental duty, or child abuse, including incest. So if those are the charges against the defendant, a spouse cannot invoke this marital privilege or spousal privilege and refuse to testify. That does not apply. And of course, you can see that that those cases have to do with the children, and those children are the children in those cases are the victims. It's not the spouse, so they cannot invoke the privilege and refuse to testify in those cases. It's like I say, it's very common that this happens. Some courts will require that you produce your marriage certificate so that they can make sure that you're married. Some courts will just have the spouse be put under oath and do what they call a colloquy. That's just sort of a questions by the judge to be answered by the alleged victim. In this case, questions basically that: are you married? Is the defendant your spouse? You're married at this time and you refuse to testify. They will also alert them that if they don't testify, chances are very good that the Commonwealth may not be able to proceed, and the case may get dismissed. So the judge will want to put that on the record as well. So it's very important that if you have a case, a domestic case, and the only witness is your spouse, oftentimes we can get these cases dismissed if the spouse does not want to go forward. As I say, it's up to them. They hold the privilege. They can invoke their right to not testify, or they can waive that right and testify anyway. It's up to them. So that's our tip of the day from Afford Law. And as I say, at Afford Law, we do practice criminal and family law throughout Massachusetts. We set all of our fees on a sliding scale, which is based on your income. So that means that the less you make, the less you have to pay. At Afford Law, we're making justice affordable. Thank you.